Yes.
Offer. There's no acceptance.
His offer to me is not accepted.
There's no contract.
No contract at all in the initial. So that is one of the aspects that in 11 your lordships can look at. At least that aspect the lordships can straight away look at.
No contract.
No contract at all here. And he also thought that. That's why I went to IBC and commercial food earlier, which he withdrew. And then finally, as a third afterthought comes here. First you go file with Section 8 notice under IBC. Then you give me a notice for mediation for commercials. Then after that you say that no, now I'll go under arbitration. And all your letters are saying please accept this mandate, etc. Well, I have never accepted it. And for the High Court to say that there is an arguable case, there can never be an arguable case under 11. Either there is an agreement or there is no agreement. You can't take a with great respect and ambivalent view that there is an arguable case, therefore we'll appoint the arbitrator.
Yes.
These are my lord.
Yes.
My lord, kindly see, my lord, the arbitration agreement again just for a moment. In the letter of 7 July 2017, my lord. And your lordship, just see page 33, my lord. Your lordship, just see page 33. That is annexure P1.
And my lord, but by letter by itself will not ask.
Yes. Right? Now, my lord, there is also, I absolutely accept that, my lord. There is no question. But if that was all, then, my lord, there was no question of, yes. Now I am showing your lordship, my lord, how this was acted upon by the petition. So that your lordship will see this very mandate letter was acted upon.
About the letter dated 7th January, 7th July?
Yes, my lord, 7th July. Would your lordship just see that for a moment, my lord?
Yes, yes.
Page 33.
33, correct.
And my lord, the annexure is at 34, the attachment to that letter. And my lord will just see on the top of it, on the left hand side. My lords have page 34. Lord, on the left hand side, your lordship will see a reference number. So, my lord, this is the reference number of this letter. And the arbitration agreement, your lordships will find at page 39. So, the arbitration agreement is there. There is a reference number which your lordships will just keep in mind. The last 4 digits are 1005. Now, my lord, after sending this, no doubt I sent a reminder, but thereafter I raised invoices. Would your lordship just see those invoices, which your lordships will find?
Happens to be last paragraph at page 41. Page 41, last paragraph.
Yes, my lord. I'll answer that also, my lord. Yes. So I said, please sign the duplicate copy. No doubt about it. It was not signed. Now, my lord, this has been acted upon. That's what I'm showing you, lordship. This very mandate letter has been acted upon by parties, which is what I'm showing your lordships. And that is why I'm requesting your lordships to see the invoice. And it is our case, my lord, at least in pleadings, that they accepted it and they said they would pay in accordance with it. Now, please see page 466, which is part of my counter affidavit. My lords have that. Please. 466.
What are the dates of your invoice?
So the invoices are dated after that your lordship saw was 7 July. These invoices are in August, September, October, November of the same year.
August?
19th August 2017. I'm sorry, there's one before that also.
The dates, please.
There is before that and after that. There were invoices sent before. One invoice was before, that was 15th of April 2017. That is at page 465. Annexure 21. My lords have Annexure 21.
No, 15th of April 17.
Yes, that is one of them. Thereafter, my lord, 7 July is my, and this your lordship will see invoice number doesn't have any reference, doesn't have that particular. Then your lordship will just see page 466.
No, give the dates of those invoices.
Yes, my lord. It starts with 15th April 2017, then 19th August 2017, 9th September 2017, 19th December 2017, then my lord, 7th May 2018, 2nd August 2018, 7th May 2018. These are the invoices.
7th May you already said.
2018, this is the next year.
7th May 2018, 7th August 2018. 2.
Yes, madam. 2nd August.
2nd August.
Yes, madam.
2nd August and then 7th August.
And then 7th May, well, they are a little back and forth. Madam. The invoices are not in sequence here in this.
So, of which of those invoices that he paid?
Yes, so now, my lord, lump sum was paid to me. 10 lakhs was paid on 6 December 2017. And all these invoices your lordship will find bear the same
6th December 18.
6 December 2017. So, my lord, every invoice of mine has a reference,
How much? 11 lakhs.
approximately, yes, 11 lakhs.
But he said 11 lakhs, 8,063.
Yes.
Is that the same amount?
That's the same amount.
Some kind of a settlement. What is the
Yes.
date of that? When
No,
you
that
paid
payment
11 lakhs?
is in December. Partly it is paid on 6th December 2017 and some part after that. But the entire amount was in December payment of 2017.
December 17.
17. And my invoices all bear the reference number to the mandate letters.
6th December 17. Yes.
So, my lord, that is one point that in our submission it has been acted upon. And therefore, it is something now for the arbitrator to
Is
decide.
there an enclosing letter with the payment?
No, there is no enclosing. They are all bank RTGS. So, my lord, this is one point that I have issued invoices referring to the mandate letter and payments have been made.
How did they respond to indicate in which manner and for what purpose the amount of 6th December 2017
No,
was?
they say in their own pleading that this is paid towards your bills.
Where is it?
Your lordship will see these payments are all.
What is it evidenced in?
There's all it is even in the synopsis here before your lordships. May I just show that, your lordship?
What is that? How do they explain it if the payment is made? In what context or to get rid of you? Have they said that?
Lord, first, would your lordships just see page L, my lord, which is of the synopsis. L, capital L.
Yes.
That's my lord justice. Aradhe got it. Page L.
LN.
But even before that, I have represented them in the section 11, etc. in that same proceeding for the purpose of appointment of arbitrator in that arbitration.
Stage they would have done. They would have marked for them. Anyway.
Then, my lord, 2016.
What is there at L?
Yes, 2016, my lord. They say after the tribunal was constituted for the Siemens arbitration, respondent continued to render legal services for representing the petitioner in the arbitration. Respondent was inter alia instructed to prepare replies against the Siemens Limited and or communication from its lawyers, taking instructions, drafting pleadings, briefing counsels, appearing in the proceedings and providing such other legal services for defending the petitioner in their arbitration petition. Which he did. He was doing it. And my learned friend has said he kept appearing without instructions, but we kept writing at some point that if you don't pay, discharge us. They were not discharging. Finally, he just recused himself. That will also come, my lord. Then your lordships will please see at page N is a reference to 7 July. I'll skip that, my lord. Then please see December 17 at page P, capital P. December 17. My lord, sir. That's my lord Justice Narasimha at capital P, December 17. Petitioner repeatedly informed the respondent of their unsatisfactory professional services, but would not be required as they already engaged another law firm. But he was repeatedly saying, give me a discharge, because the wakalatnama of the respondent continued till the end, till he recused himself. Despite the same, respondent continued to raise invoices for its purported legal services, so they accept the invoices. Respondent refused to withdraw until and unless he gets paid. There's nothing on record to say that, not a single letter at all. Petitioner paid a sum of 11 lakhs 8,163 as full and final settlement in December 17, which was duly accepted by the respondent. This is something to be tried. This we are not admitting. So they are accepting that on the invoices they paid this amount, but according to them, this is full and final settlement. According to us, it is not full and final settlement. So it's not satisfaction. After 1 year, after almost 8 months, 13th August 18, he had to recuse. Respondent intimated the petitioner and the tribunal that they will seek discharge as petitioner's advocates in the subject arbitration proceedings. And then after that,
Between
between that period,
is there any correspondence between
there is nothing.
your letter of correspondence and the notice for appointment you? Have they written any letter?
No letter is written to me to say that do not appear. He has appeared 13 times. 13 times is not even a small number, my lord.
The reply is only on 7th January 22. Isn't it?
I'm sorry, my lord. His
Reply is only 27th January. Page 69. Show us that.
Yes, my lord, I'll come to that. Would your lordship just see? So, my lord, my learned friend has said we appeared before without instructions, etc. There is not a single letter saying that stop appearing. Wakalatnama continues. Wakalatnama continues till the end, till he finally says, now, please give me a discharge. Then he has to recuse himself from the proceedings. Then he stops by himself appearing. But otherwise, his Wakalatnama also continues. Repeatedly appearing. There is not a single letter, my lord. Not a single letter from their side saying, why are you coming to the tribunal for appearances? Why are you coming? All along, as they themselves said, my lord, your lordship saw at page K and L, they have themselves said he was supposed to brief counsel. He was part of the proceedings. He had to appear in the proceedings. It's all okay now, my lord, to say in retrospect that we did this and we said that and all that. But all along, he was representing them. Not a single, otherwise at least one letter would be there telling him, don't appear. We don't want you. It's all right to take services, my lord, and I of course understand your lordship's sentiment also about the arbitration agreement, but some advocates do include an arbitration agreement in their letters. My lord,
We have not seen anyone.
I have also not seen, but at least here, my lord, I am seeing now. I have also not seen, I must confess to you.
Can't be.
But,
Can't be.
Lord, I mean, I can conceive some people doing it, but
No, you can't be. It's not permissible. We are all professionally bound by the Advocates Act. The conduct between us is to be governed by the Bar Council.
but my lord, ultimately it's a contract between parties.
I intended to have an arbitration clause.
Right.
At least we have not seen. Anyway,
Ultimately, it's a contract between parties. So I have not come across. There may be, but I have not seen any bar under the Advocates Act.
just
So, my lord, this is so.
not
Therefore,
drawn any conclusion.
yes. So, my lord, therefore, one point is just to emphasize to your lordship, my lord, that he has appeared throughout his file Wakalatnama, which continued way beyond even till 2018. Your lordship saw that.
So facts are just this much.
Yes, and there's something more. These are the facts of appearing, etc. That's all, as your lordship said. That's all there is. Yeah, they are paid on the basis of his invoices. They themselves say that we paid, but according to them, full and final settlement. That is, in my submission, something which the tribunal can decide. Now, my lord, the second part.
Issue IBC.
So that was, he never went to IBC, he never went. So he issued a demand notice. He said,
Just ask, I understand the lawyers mind. Issue an IBC notice to a client.
Lord, I think as some lawyers at least may be just like any other litigant. So,
Indicative of the mind. I mean, put somebody to pressure this.
that all persons who are owed money do that. So they issue some notice or the other, either an IBC or a suit, a notice to file a suit. But anyway, I can't go beyond this. I cannot explain more than this, except that it is one of the methods of trying to get your money out. What else can I say? Because there is no dispute on the invoices till afterwards. When they sent the money also of 11 lakhs, they don't say this is final settlement.
You are not even a minute saying that the lawyer is not entitled to recover money from this.
No, that I fully appreciate.
You never say that. But you have a right, you have a DN over.
Correct.
despite some judgments of a court saying that you can't have a DL. But anyway, why not? Gave your services, you have a right to take the money back. I mean, whatever the effort that you have put in, or else that's the respect that you have for yourself if you want to recover it. Why not? But that doesn't mean that. Nice.
The second submission, I'll just point out to your lordship what has happened also, my lord, during the proceedings over there.
The arbitrator.
Yes, before the arbitrator. Just one. After the review petition was dismissed, because the review was dismissed on 16th April 2024. On the next day, parties appeared before the arbitrator. My learned friend says the arbitrator said this and that and the other. There was nothing of the sort. Kindly see the minutes of that meeting. Before the learned arbitrator, parties agreed to file their pleadings, lead evidence, and also files statements of defense, etc. Cross-examine the witness. So they have, in one sense, I respectfully submit. They have accepted the appointment of the arbitrator. Just see, my lord, just see the appointment. Just see that the minutes, my lord. I'll just show that your lordship the minutes of that meeting.
There's no option for them, no? If we dismiss it, they will have to do that. Or else they would have faced an ex parte award.
No, but they had an option of telling the tribunal that I am filing an SLP. Nothing is there. Please see the minutes. Just see the minutes, my lord.
Just shows them.
Yes, my lord, I'm just showing you. Yes, the minutes your lordships will find in the additional documents. Annexure A at page 8.
Dennis?
Yes, your lordship see page 8, my lord. Sir, would your lordship just give me a moment with my client? I'll just have a word with him in case he accepts my suggestion. Supreme Court said something, forever you will be stuck with it.
How do you explain those subsequent invoices?
No, in fact, those invoices were part of his Section 8 notice to me. And there he said this has been paid. Those are not, they may be subsequent, etc. But the payment was made for, when he sent me the IBC notice, he admitted that even at that stage I paid that 11 lakhs because that was a previous work done. Acting on the mandate, I've never acted on the mandate.
You're saying that the payment of 6/2/2017
Yes.
is towards what? And where have you answered that?
6/12/17 is for payment for the work done pre-mandate sent by him. He was working earlier also for us.
Prior to 7/9.
Correct, that's my point. And therefore, I'll show you one document, I can show there's no letter, but there's a document which Process will see, which is at page 55 of the SLP paper. Please have a look.
this is when, much before arbitration. Now we have not reached the stage of arbitration. And before that, he sends me not this section 8 notice to me. Sorry, if your lordships have page 56. SLP paperbook page 56, your lordships have? Yes, well, now this is, it says, this is a demand notice invoice demanding payment of operational debt due from Parkour. Please file particulars of the unpaid operational debt. So now he mentions, my lord, a debt, if your lordship add it up to, it comes to 11,8,163. This is what he's saying. And thereafter, my lord, he also raises a further amount. Now he says, please read further at page 57 with me. Part payment with respect to invoice so-and-so was received on 6 December for an amount of 10 lakhs. Part payment with respect to invoice so-and-so was received by NEFT on 6 December for 1,8,163, totaling 108. Then he says, further amount due, total amount due, etc. is 44 lakhs. So, my lord, this is, my lord, next serial number 2, amount claimed. My lord, page 57 bottom. So, this is what is claiming.
There is a total of 9 lakhs.
That comes to a total of, my lord, no, my lord, it comes to a total of 34 lakh principal and 9 lakh interest.
So you are saying till so far as item 1 is concerned, one related to the previous.
That's what my case is. Absolutely. And my lord, the question.
1 minute. Number 2 relates to the present arbitration.
Present, and secondly, his case today, my lord, let's cut across this. His case is based on an unsigned unilateral mandate. He can go and file any other to get your answer. Yes, so what I was saying was, Lord.
So therefore, you've answered the point, I think.
That's what I'm trying to, that's my answer. Yes.
Of the IBC claim,
My lord.
first relates to previous time.
Yes, correct, we paid.
The later claims
Yes.
relate to the present one.
Because according to us, he did nothing after July 17. Correct, that's right. That's my case.
Lord, please see that same document which my learned friend. And
Makes sense, then the payment makes sense.
please see para 2, please find particulars of the unpaid operational debt. And please see what he's saying is towards debt due inclusive of taxes so and so amount as on 1st August 19. And below that is the caption. What is it for? Non-payment of dues for appearing before the tribunal, consulting, preparing petitions and documents and arguing matters, Messrs. Paharpur Cooling Towers Limited. Arbitral tribunal was the only arbitration, the same one, before in the Siemens arbitration. Then he gives details of invoices which are paid. He is giving details of invoices and saying payment received 0. Please see, payment 0. Then another invoice which is of August 17, which is after July 17. Payment received 10 lakhs. Another invoice which is of 9 September 17. Part payment is received, which is 1 lakh. Then the next one is 0, 0, 0, 0, 0. So these are all the invoices.
Other heads, interesting.
So they are all under the same head. Non-payment of.
No, first one is about what? Total amount. Non-payment of dues to the arbitral tribunal.
For appearing before the tribunal. It is the same arbitration of Siemens. The same Siemens arbitration.
Outstanding 9 crores towards one. Amount claimed to be in default. No, what is this about? Number 2. Number 2 you haven't explained.
Yes, brother. I'll
Number
explain.
3, particulars of the security held. If any. None.
Yes. No, my lord.
All none. Oh, it's on the format.
This is a format. This is a IBC format. You have to issue a format. So this is that format. So this letter, my lord.
What's the second head then?
Second is
Or less.
amount claimed to be in default.
What for?
Item 2. And that is the your lordship
What's the instruction?
yes. Yes. So, no, I suggested to my learned friend that maybe he should just prosecute the suit instead of.
You have a right to do whatever. Choices, we will never force anybody.
No, I'm not even saying your
We will
lordship.
take our call.
I just thought that, my lord, I should at least put it to him if he was inclined to do that. And, my lord, he seems to be all right with that. That the arbitration then can go.
What do you say? Take your choice.
I think he has made his choice. Ask him one last. He has made his choice.
Trying to accept the existence of an agreement.
No,
But you leave it.
I don't want to get into it since
I didn't want to
he's
tell you.
agreeing. You might as well put an end to it.
It makes sense. Sorry. We leave all your rights
So that's
intact. All your rights.
fair enough.
You will not express any opinion. Why should we express it? Shall we pass orders then?
Yes, ma'am.
Or we will just record. It's even better for you
Yes, my lord.
if after consultation, if you make statement
I'll do that.
your
Yes.
client is
He's here,
client
so that's
withdraw section 11 application,
yes.
matter ends there. We will not say utter a word on that. So everything is open ended.
I'm obliged.
Take instruction. Take instruction. Or the section 11 leading to consequence.
Yes, yes.
Everything will.
This was just a technical point my learned friend is raising, but obviously once the section is
Listen, what do you want us to help?
he's only saying that 11 is decided, so the arbitration has to be closed. But I think that's fine, my lord. 11 can.
You can couch it. No problem.
That I'll leave it to your lordships to put it in whichever way.
As the court was considering the maintainability of the section 11 application, leading to the constitution of the arbitral tribunal, Mr. Asham Mehta, learned senior counsel, appearing on behalf of the respondent, orders passed by the High Court, orders dated
So my lords
24.
may permit me to withdraw so that the orders will automatically get sent.
So all the orders has to go now.
Yes,
Then
but
the orders
your
will
lordships will have to first permit me to withdraw.
in view of the statements, how do we say this? Set aside the orders then. Order has to go. That's what I'm saying. They accept the submission, and consequently, orders 21 orders of the High Court dated 21/4/23, 21/2/23, 24, and the 6/4/2024 will set aside.
It's 21 to 24, my lord, the second.
Here, 1/2/24 are set aside. We make it clear that as there is no decision by the arbitral tribunal nor by this court, the respondent will be entitled to initiate such proceedings as they may be. It's a firm, is it?
Yes, ma'am.
As it may be entitled to in law. So, the period commencing from
On the date of the notice, ma'am.
From-
Lord, may I also be permitted to withdraw that notice of arbitration? So that the whole. What is the date?
doesn't matter, consequent. How does it matter?
23rd December 21 notice also. ma'am.
Okay.
Yeah.
Seeks to withdraw. What did you say? Seeks to withdraw. The seeks to withdraw. Are the instructions? The notice dated 23/12/21 and the section 11 application.
Yes.
All right. Yeah. And it is for the court to decide it, for the concerned group to decide the case on its own merits. So, the period spent in prosecuting the arbitral period
Obliged.
Thank you.
I apologize for the distraction, my lord.
No, that's okay. You will disturb your senior.
My lords, in item 10, I request for a passover.
There is a letter in this matter in item 10. I am for the petitioner herein, and the respondent number 15 to 17 has moved a letter for adjournment in this matter on the ground of bereavement on the counsel's family, who is also the petitioner in item 10.1.
Okay, come on, next Tuesday.
Much,
Next Tuesday.
much.
Next.
Well, grateful, man.
Item 11, I'm requesting for a Passover. Learned AUC, Mr. Banerjee is leading us in this matter. Please quote of it.
Right.
Code 5.
Okay. Tuesday. ये सभी को Tuesday जाएगा.
Much obliged.
Item 12.
Yes. Well, I'll have to give a little background.
But actually, we were thinking that why is this matter come to us?
Because the
Because it should also.
Supreme Court order says
Just one
against.
minute. Just one.
My friend Murad is an expert.
No, I'm not.
No, he is because he's
One
been
minute, we were
saying it
thinking that we will
genuinely.
No, we will not put the burden on you to explain or anything, not necessary. We will take instructions. We will,
Well, may I just tell two friends?
Come to us.
what we are saying is that it appears that it was following Justice Satish Sharma.
Yes, it was.
Yes.
So let it go there. We asked the listing. Said they will find out. Just wait for a week.
Very well.
Okay, get listed somewhere out there.
Yes,
Very well.
In a week's time,
there are 1-2 other IAs which are not listed. Whenever it gets listed, may I give that IA number?
in a week's time. Don't worry.
No, minute. The IAs which are not on board today, 1-2 other matters are also joined.
Speaking of the matter, my lord will not even
Get
pass
listed
that.
next.
No, your lordships are not recusing, so your lordships are not denuded. Correct.
I'm not recusing. I will find out because we are doing already one of
I
those.
understand. But whichever court it goes, there's no difference.
Bhattacharya. It's coming again tomorrow. So we'll see.
Very
Just give us a week's time. It will get listed either before this court or some other.
Yes. Only one.
If it gets here listed, we'll hear you.
Very
Just
well.
wait for a week's time.
And only one worry I have is, there's one auction that has
Auction
been
going on.
conducted. I don't know if they have succeeded. If they succeed, if the auction proceeds are disbursed in the meantime while the matter gets listed, if they can just stay their hands, I'm not asking.
In a week's time. Just
My lord, it is unnecessary.
in a week's time, nothing.
My lord, it never happens.
Who are you appearing?
My lord,
Committee.
appear for NSC. My lord,
Is somebody representing Justice Nandrajog's committee?
No,
my lord,
not a party.
he's not a party.
No. In his like in the other case.
No,
No, not at all. Not like. My lord knows the judge, he will never do that. Never defend the order.
No.
Are assisting the
It's assistance. That's all. Not about it.
Very well, my
This
lord.
is yet again, I don't know why we getting into all this. Supreme Court is getting into all this. And it's so difficult. I remember that Unitech, when Deepak Mishra was taking it up as ASG, I said, don't get into this, send it to IBC. So he said, so many people all over the country are suffering, we can't. And that continued till I became a judge. And it's not over yet.
It's still going on.
It's still not over. So I said, as a law officer, I will assist you, but we don't have the time to engage in this kind of distribution. But there must be some method. Why should this not go to IBC proceeding? Will it not go to? Is it typically not a situation where?
No,
No. Why should it not go to IBC?
no, it's an unusual. My lords, I have made a background note. If my lords will take it up and circulate, my lords will. That's why I said I will give a background.
But separately, my lord, the concern my lords expressed not on the merits of this matter. If the earlier direction of this honorable court that against every order passed by the committee, an application would lie only before this honorable court, the committee virtually substitutes my lord a civil court in execution. So an order 20
appeal.
Yes.
So first appeal is before this honorable court. So if a garnishee order is passed, if an objection is filed, it has to be conducted like a suit. So an order passed, my lord, will be like a decree. And my lord, the applications that are coming in this matter, all these IAs, have the character of a first appeal that needs to be conducted.
This the National Spot Exchange comes under the
Company merits.
Companies Act.
Just a company.
It's who is the regulator for it?
Ministry of Corporate Affairs.
Forward markets.
Forward Markets. Forward Act under the TACT.
Yes.
So SEBI is the regulator.
No.
No.
SEBI is not correct.
SEBI is not there. So against that statute, there must be a statutory authority, appellate authority.
These issues are not arising.
That is where it should go.
It's under that act.
Well, that's why subject matter. There is something which I need to give. It's a real estate matter. Property is brought to sale. So
That's different.
that's different, Manas. This is anyway. We'll understand. Why bother my lords today in the fag end of the district? Very well, man. Great.
We'll also find an act.
Don't say anything more. Just wait for a week.
So that may be also an answer of the registry.
Say it's not happening.
It's okay.
Grateful. Registry.
Give the IA number so that it is clear.
This as I'm looking at matter. The two Justice Bela Trivedi's two order. Niranjan, Justice Bela Trivedi's order are two orders, no?
One order confirming two orders passed by the committee, upholding those two orders. That we will be, whenever the
Two orders, right?
Yes.
No, there were two orders passed by the committee, and both of them were then
What
upheld
are the
by.
dates of those?
Well, the dates of the are 23rd of August 2023 and 8th of January 2024 are the dates of the committee's
Set of
orders.
orders.
Yes, Mullah.
In both of them.
Both of them were upheld by the judgment of 15th of May.
This is interplay of
About Supreme Court judgments.
15th of May.
Only one judgment of
Yes,
one judgment covering two issues. Very good. Being listed in a bench comprising of instructions. The registry shall take instructions for appropriate listing of the case. Proceedings में नहीं, note के जैसा. Mentioning some clauses. Briefing listing of receipt. Right. Private next time there's nothing in this case which goes on. ये property sale कर रहे हैं, मेरे को बहुत लाभ आएगा, कम sale कर रहे हैं. And these are matters you can't just hear and dispose of. As if we are sitting there like doing every day. Next year, the 193 to post the bifurcated in the state can come and that civil business. Right to pay attentions.
नहीं दोनों तो the central
portion
all these matters are connected to the TN.
Which matter of arbitration.
My lords, in item 13, I am appearing for respondent number 2 and 3, MOEFCC. My lords, I am being led by Miss Archana Pathak Dave, learned ASG. My lords, she is on legs in code 14. So, my lords, my lords is logged in and on.
Yes, Mr.
Unmute yourself, sir. We can see you, but we can't hear you. Unmute yourself.
I have unmute, sir, but
I can hear.
yes, Your Honor, I am for the petitioner, Your Honor. My only submission, Your Honor, as per the office report, the counter has not yet been filed by the respondent number 2 and 3, Your Honor. My only submission, Your Honor, let them file the counter so that fixed for the final argument.
This is final argument. Tell us.
Your Honor, my only submission is let the counter be filed by the respondent number
And
2.
then grant us some time to file the counter, my lords.
Sawmills, there are rules. Is there a rule made here?
Your Honor, because even before the Patna High Court, Your Honor, the Union of India has not filed the counter, Your Honor. 2 and 3, the Ministry of Environment, that is the important respondent, Your Honor. They are supposed to come with the, because how the state of Bihar can they surpass the Your Honor, Union of India? Their report should be, their counter should be on record, Your Honor. This service is completed, Mr. GS.
What is the law which governs or prevents increase in the number of sawmills?
Your Honor, the issue is that, Your Honor, 3,200 license has been distributed during the pendency of the petition, Your Honor. The petitioner
What is the law which applies with respect to grant of licenses for setting up sawmills?
That law has to come, Your Honor, from the Union of India, Your Honor. The state of Bihar, the special committee has been constituted, but the actual report with regard to the law is not clear, Your Honor. The Bihar is not having any forest, Your Honor. They are supposed to import from different states. Even the persons who are already holding the license, Your Honor, they are not fulfilling the requirement. They are not able to fulfill the requirement in the different.
There are a series of orders relating to setting up of sawmills. In that, there are some guidelines.
My lords.
Find that out, put those guidelines. Under the guidelines, you must be knowing.
Your Lordship, can file a reply. We follow the union notification.
You are for whom?
State, Your Lordship. We follow the union notification. We constituted a committee, and the committee examined the relevant criteria.
A large number of sawmill orders were passed. Compile them and then see in one of those which are published. But otherwise, guidelines and rules were also issued.
It is settled, my lords.
Then,
As per me, it's settled. We'll just write in a counter and file.
next Tuesday. Find out and tell us.
My lords. My lords may give 2 weeks if.
Next Tuesday come. Just actually apply our mind. It's no point in postponement.
Wait, please.
Yes.
But it's a short point.
Yes.
But on whether, my lords, the complaint can proceed. But they've been served. Nobody is appearing. They didn't appear before the High Court also.
Partner of the firm. What happened? What's the story?
No, just a short point, my lord. My lord, here
We
the
dispose of
company.
it.
Yes, my lord.
Have you set them aside? Set them as ex parte?
There's no formal order, my lord. I can, my lord.
Who is state of Gujarat? No.
Yes, my lord. But this is a private company.
What are you saying? This goes times.
No, my lord. It's a private 138 complaint, my lord.
But anyway, at least state will be there.
Yes, my lord. They have been served, my lord.
Service copy of the specialty petition on the
Yes,
a copy of the SLP shall be
Wakalat is
served
there.
on the standing council for the state of
My lord, Wakalat also is there on record of the state, my lord.
At least serve on them.
Yes, they'll serve.
At least next Tuesday.
Tuesday will be a miscellaneous day, my lord.
Wednesday perhaps. No, sorry matter आज के ना Tuesday, Wednesday
Okay. Grateful.
Okay, it's covered by
Anita Hada, my lord. That's fine. My lord, here if the company is not arrayed as a party, it has completely, my lord. Okay, I have placed the judgment also. But can I just have a hand over a copy?
in the state. There will be somebody when we're going to set aside the order. Somebody.
Very well. And Anita Hada has been subsequently followed, not as recently as in 2025 itself. But if I've paused all these prosecutions.
You know that.
Yeah, grateful.
Covered it.
My lords, I appear on behalf of the petition.
Right. My private company. Besides the check. Right, what if it goes? Right, okay, they can still arrest them. But what's the criminal proceeding? Because I get me. What you should do at most? I said, what? We can't proceed. You know, to implement the part. If you spend out, then what's the proceeding? you are asking this photo? Which one? I guess you.
Yes, my lords, I appear on behalf of the petitioner, my lords. I am being led by Mr. Balbir Singh, my lords, and he is unavailable, due to which I seek a short accommodation.
Not necessary, because you are very capable of handling it, and these kind of chances come very rarely. Come on, let us see.
My lord, but
What is this case?
my lords, this is basically an application under 319 that was filed before the trial court, and
You are who? Petitioner. You are
petitioner, my lords.
You are accused.
My lords, I was arrayed as an accused after my 164.
Oh, you are challenging the 319 order.
Right, my lords. My lords, the 319 was dismissed by the trial court,
High Court.
but the High Court in revision has.
What stage? When did the trial start? What is the FIR date?
My lords,
2019.
2019. My lords, the
Are you
trial.
there in the FIR?
Pardon, my lord?
Were you part of FIR?
No, my lords. I was named in the 164 statement, my lords.
164. Then in the charge sheet you were dropped.
My lords, yes, my lords. After the charge sheet, my lords,
The charge sheet filed.
my lords.
18/11/2019.
What is 18/4/2019? What happened? Two-phase trial only.
My lords, the trial has been.
That is what they say.
My lords, the trial has culminated, my lords, and the main accused, Vijender, has been acquitted in the trial, my lords.
Oh,
He has been acquitted in the trial, my lords.
when was that happened?
My lords.
So therefore, the main judgment has been delivered.
Right, my lords.
What's the date of the judgment? Okay.
My lords, it's filed in the additional document. 22/7/2025, my lords.
Okay. Did you get a stay here?
Yes, my lords.
You got a stay. Alright.
And my lords, the
Judgment is
revision was
delivered
preferred by
on
the complaint.
July. Okay, after the stay here.
Right, my lords.
Yes.
And what happened? What happened against that?
Against that, against the acquittal, my lords.
If we allow this petition, the entire trial has to now review.
Your Lordships, however,
Already got acquitted.
yes.
Main accused. State has filed an appeal against
Your Lordships, no. We have filed a counter, Your Lordships. No appeal, Your Lordships.
that judgment.
Your Lordships, those instructions are not, but as on date, as per my
The
instructions.
daughter had turned hostile, my lords. The daughter of the main accused, my lords. The victim. And she is currently residing with the father, the main accused.
Daughter in herself has become
Hostile. Right, my lords.
so who will come? There won't be a private complainant here.
No, my lords.
We'll allow it then.
Your Lordships, on that, however, I'm just pointing out their pure legal proposition, Your Lordships, that under 319, they're saying they cannot be. However, Your Lordships, that is irrespective because prior to Your Lordship, they are saying that cannot be arrayed as an accused. Yes, Your Lordships. So,
Now it's clear.
yes. So that's
Anytime.
at any time, yes, Your Lordship. So my
But the daughter has turned hostile, my lords. She, on her statement itself, I was arrayed as an.
You have the judgment.
My lords, it has been filed with the additional documents as annexure P15, my lords.
Please grant it. The issue now. The non-accused in the criminal proceedings initiated on the basis of an FIR dated 18/2/29 was sought to be prosecuted under an application through an application under section 319. Was acquitted.
Daughter, victim.
Of the victim's daughter.
Of the Milord, she herself is a victim.
Your Lordship, sir.
What is the offense here?
Your Lordship, the FIR was that there was a fight and he threatened. So he is, Your Lordships, he is a person.
Of the victims of the
Victim herself.
that's all.
Right.
That's the victim, right?
Right.
Victim. Okay. 64 statement, son, minor son took name of the petitioner. Okay, ऐसा बोला. This is in view of the fact that the petitioner, apart from the fact that the criminal case as against the main accused culminated in his acquittal. Sola,
Please, Milords.
Circle Ja, what is to be done?
Milords, the private respondents have to be implemented, Milords. I have filed an implement application, Milords. That has to be allowed. And a notice may kindly be issued to the complainant. State has filed its wakalatama yet to appear, Milords.
You are who?
Milords, I am the individual, Milords, who I was a director. I was convicted under 138, Milords. Against the conviction, Milords, I filed criminal revision. Now my criminal revision is not getting listed before the High Court and the exemption for surrender for the simple reason that the High Court says that under the High Court rules you have to surrender.
What did we do?
Milords, Milords have granted us protection, Milords, from the surrender.
And what happened to the criminal case? What's
Milords,
happening?
Milords, it is pending there in the High Court, but it is not getting listed.
What is pending in the High Court?
Milords, my criminal revision.
Tell us a couple of things.
Yes.
You were convicted by the trial court.
I was convicted by the trial court under 138.
Then you file an appeal to the sessions.
Yes, Milords.
Session is not hearing because you.
No, session has also heard it. Conviction has been upheld. Thereafter, I filed criminal revision before the High Court, Milords. My criminal revision is not getting listed for the High Court because the High Court says.
Right, we will confirm that our interim order we passed. Please argue your.
Milords, it has to be listed, Milords. That is, the direction has to be given.
Big question of law. Especially petition is against, they've granted the appeal is against the decision of the High Court of Rajasthan in criminal revision number 1870 of 2025 dated so and so. The short question that arises for consideration is whether the High Court, don't say like that, don't even question of law. The High Court, the petitioner, the appellant is before us on the sole ground that the High Court refused to, they didn't permit you to pursue your revision till you surrender, right?
Yes,
The petitioner is before seeking suspension of sentence. The petitioner is before this court only for the reason that the High Court did not refuse to suspend the sentence till he would surrender. While issuing notice, this court passed an interim order on 2011-2025 exempting the petitioner from surrendering pending disposal of the revision before the High Court full stop. क्या वो है ना petition जो है ना revision petition the facts and paragraph in the facts and circumstances of the case we are of the opinion that that the interim order passed by this court on 2011-2024 should be confirmed and the petitioner should be pursued to should be permitted to pursue the revision before the High Court. In view of the above, we allow the appeal modify the order passed by the High Court by directing the suspension of the petitioner, suspension of the sentence of the petitioner. What is that? The sentence of the petitioner shall be suspended and the High Court shall proceed with the that they have said suspension. Suspended and what is the petition number? The High Court. We request the High Court to take up and dispose of the revision application as expeditious.
Well, as kindly mention the revision petition number or revision petition number. That is well there in the order 20th.
You go there.
Yes, but that's not what this number has to be mentioned.
Which state is this?
This is the state of Rajasthan. The revision petition number 2068 of 2000.
Please brought the standing council for the Rajasthan. Why are we passing expeditious
File wakalatnama, but
we'll pass it over. Order will remain.
okay.
This will record a phone a standing council.
Well, Shimangal Sharma.
Call Shimangal.
He is a double aging.
Flash kar do. You be there before we raise. We will record his name.
Plus this revision has to be mentioned. This is a revision petition number 2068 of 25 and 2069 of 25. Much. I'll just inform you. And Nidhi Jaiswal is a standing counsel. Nidhi Jaiswal is a standing
I
counsel.
appeal for this state, my lords.
Next, Shimangal sir.
Shimangal Sharma is a double aging.
My lords, I am appearing for this state, my lords, in the matter.
In matter. Okay, who is
In
the
item 16. My lords, Miss Nidhi Jaiswal is the advocate on record. I am the panel counsel, Anisha Rastogi.
Okay. Just record her name, Anisha Rastogi. Much same order. Thank you very much. Appears in the state. Next.
Speaking of, I'm appearing for the petitioner, Manoj. Manoj, I'm seeking the short accommodation, Manoj. I'm under the weather, Manoj. I informed my learned senior. Manoj, I'm seeking a short accommodation, Manoj.
What is this? Arbitration. 24.
Manoj, this is under the old act, Manoj. Under the 1940 act, Manoj.
Next Tuesday.
Wednesday.
Wednesday.
Wednesday will be MMT day.
बहुत दूर हो जाए.
Tuesday week, perhaps.
Tuesday. All the matters today, Tuesday, which are getting adjourned, post it on next Tuesday. Not Tuesday week. Which we will tell you what. Yeah, what?
Item 18, we've
But
circulated
no,
a letter.
all matters will go on third. Today's matters if they are getting adjourned.
18 Union has been circulated a letter, my lord.
18.
That affidavit has to be filed.
My lords, I just have one request. It was September. My lords, my lords, may grant us 4 weeks additional time.
Of the state we have filed, my lord. Union has to file that affidavit. They are saying.
My lords had directed in September. They had given them 4 weeks. So, my lords, no further adjournments and a fixed date. Because these are primitive, particularly vulnerable tribal groups. 4 more weeks will most certainly file an affidavit with them. Next.
I'll file third. List on third by which point?
Please.
Last chance we are giving.
Please, ma'am.
File it and bring it on record. Patta we communicate to.
Please, ma'am.
On behalf of the state, we have filed that affidavit. I will communicate.
it is important to have unions.
Definitely.
Obliged.
19, I am appearing for the respondent.
My lords, may kindly pass the matter over.
This is the same matter, Mala. Every time they are asking for adjustment. Last time they dismissed.
No, my lords may not do.
Enough indulgence.
Every time they are asking.
Just count the number of times.
Yes.
My lords, I'm not seeking an adjournment, just a pass over. Dr. Singhvi is leading us in the matter.
Every time, how many times?
Last time you are drawing, Mala. Last time that bill down.
Have you done anything?
They have to argue
One
another
time
time.
they say that there is some agreement going on.
No, Mala. Nothing, Mala. There's nothing.
My lords, there was a change in law and we were...
Change in law, Mala. They can withdraw this and they can apply over.
Yes, my lords, that's the instructions we were seeing.
So last time was...
My lords, may just kindly pass over the matter. I'm being led by a senior.
Sheba, come. If you come, you'll understand why you are coming. What happened?
He's on his legs before.
Not this matter, Singhvi is in code 6 at 99.
Pass over.
Obliged.
Mala, that will be taken after a week, Mala. Because now it is 19 going on, it's only 3:15, Mala.
Wait a minute. Sorry.
Wastage of time, Mala. 15 times they've asked for the
Third. It's not third.
Obliged. Obliged.
Mala, 15 times they've asked for adjournment, Mala.
You are also asking now.
No, Mala, I'm not asking.
We just gave Passover and you are asking it.
Mala, can you pass on? No problem. I have no problem for that. But can you see, but looking to the time, Mala, this was my...
May it please your lordships, I appear for the petitioner state. The issue here is the state has challenged the High Court's order whereby the grant in aid has been allowed to the respondent institution. Now there are two issues, your lordship. One, that they claim to be stationed in a hilly area. However, according to the state, the village that is concerned is not in hilly area according to the government GRs. Second, the problem is they were not following a reservation roster system. They were not following the reservation roster that was mandatory according to the judgment of the Honorable High Court as well. But later on, they have complied with it.
Under the GR, they are eligible. Freedom Verma.
Under the difficulty, I also struggled a little to find out what the point was why the notice was issued. If your lordships will see, there's a judgment of Bombay High Court. At page 190 is the operative part of it. It says that retrospectively granting aid cannot be given. Now your lordships may only see their prayers in the writ petition.
But this is a college, this is a school or an individual?
This is a school.
The respondent is a school. Yes, sir. But your proposition will be applicable if there is no petition. But if they have a petition, when did they file the writ petition?
2018 is the impugned order.
17 they filed the writ. But when did they give?
According to the synopsis in my SLP,
11.
it says they have complied with the reservation roster in 2015. So from 11 to 15, they may not be eligible for the granting aid. That's all I'm canvassing before you. Your lordships may see the prayers at page 131 in their writ petition.
When did they file the writ? That's important.
Writ is filed on 2nd October 2017.
17 is right?
Yes, sir.
17. You are right. Prospectively you are getting anyway.
They are claiming from 2011. Your lordships may only see prayers for a minute. I'll satisfy your lordships. Page 131.
There's no window in this. You दरवाजा खुला रखो. Ventilation नहीं है. पंखा भी खोलो तो इसमें सब में. Speed slow हो.
Yes, page 131 are the writ petition prayers. if your lordships will see, High Court has only granted prayer B. May I read, your lordship? 131. And your lordships may then immediately see page 8 of the impugned order. Para 9. Considering these facts, we are of the opinion that the lordships has it. That the learned counsel for petitioner has made out a case for allowing the petition in terms of prayer clause B. Insofar as the other prayers are concerned, these prayers are in respect of grant of approval to the additional post and grant of approval to the additional divisions. If such a proposal is submitted by the petitioner institute with requisite material, the authorities may decide the proposal on its merits. The institute similarly situated with the petitioner, which is entitled for benefit of grant in aid, and the same benefits granted to the other education institutes. Lordships may see para 11 of it at page 9. We direct the respondent state to release the grant in aid as expeditiously as possible. The lordships may only after this see page 190. This is part of one of the judgment of the Bombay High Court where the GR that is in question here was considered.
So what's the problem?
Your lordships may see that conclusion part and I'll leave it.
No, what you have come in SLP on the ground that para 11 is open-ended.
Yes, it allows from 2011.
That's what it's open-ended. It is not confined to 2011.
Yes. They cannot claim retrospectively. They start complying.
Is the para you are seeing?
Page 190. The heading is result.
190. That's the High Court judgment.
Yes, your lord.
In the result?
And considering this very GR that is in question, we therefore allow the writ petitions. We set aside the GR dated 15 November 2011 and all other consequential GRs and letters insofar as they insist on the petitioners complying with the reservation mandate retrospective. Instead, it will suffice if the school comply with the mandate from the date they are provided the grant in aid.
The school said that who challenged the GR?
They come up with a petition saying we are in hilly areas, give us grant in aid.
So why did the GR, what did the GR say?
GR said grant in aid is to be given on different criteria. That criteria are laid down. In that GR, there's a stipulation that you have to comply with the reservation policy while recruiting the staff members. They did not do it. Then
the court set aside the GR is what they are asking.
No, your lordships, there were different grounds on where
GR is set aside. That's why we are asking.
Only in respect, your lordships may see.
GR is set aside.
Insofar as they insist on the petitioners complying with the reservations mandate retrospectively. And what I am relying on is, your lordships may just bear with me on the last 4 lines. And we also clarify that the petitioner schools have no right to claim the grant in aid retrospectively. Nevertheless, besides exercising...
Challenge that it should not be given retrospectively?
I'm sorry, your lordship.
Who challenged that it can't be given retrospectively?
The institutions. According to that GR, the interpretation what the government came up...
Government made the GR. GR is made by the government.
Yes.
Government said it should be done retrospectively. So
they challenged it.
Schools said
the present respondent, there was a batch of petitions.
Schools?
Yes.
Not me, my lord. The other institute, the states.
And
so schools didn't want, but it will be borne by the government. Anyway.
And only in this regard, your lordship, I'll place synopsis at page P.
We also clarify the petitioner schools have no right to claim the grant right prospectively. Nonetheless, besides exercising the discretion, I don't know. Which instance it gets set aside. Then what about synopsis?
Your lordship may only see page P.
What exactly is it? We set aside the GR and all other consequences insofar as they insist the petitioner.
Yes.
So therefore, GR retrospectively giving is granted, subject to whatever you say, but requiring that to be given on the basis of reservation is set aside.
The GR is dated 2011. They start complying for the reservation policy in 50. That's what I'm trying to show from page P.
We'll take it as it is. And synopsis, what do you want us to say?
Page P, the first date, 1st of May 2018.
Yes.
During the pendency of this petition, petitioner institution has not produced the roster verification from the backward class cell, which is competent authority to verify whether the appointment have been made as per reservation policy. However, for the first time, it shows that the petitioner institution complied the norms of reservation policy on 1/8/2015. And the judgment which I showed of the Bombay High Court, that clearly says that following the reservation policy is mandatory. And there's one more problem with the impugn order.
How much retrospectivity is it?
From 11 to 15. And there's one more problem where the Honorable High Court says that this school is situated in the hilly area. It is admittedly in a village which is not part of hilly area. I can demonstrate it from the GRs. But that may not be relevant.
The whole thing is about one school.
Yes, it's one school.
The issue is only with respect to that 2011 GR. I was eligible. As per the procedure contemplated in 2011 GR, the authorities of the petitioner, state authorities, evaluated as per the procedure contemplated in that GR. And they issued the mark sheet in my favor, saying that out of 100%, 90% mark is given to me. On that basis, I was eligible. They issued the letter saying that you are eligible for that, for granting aid. That letters are also there. So for that purpose, they have not in my counter. In spite of that, they just come.
I'm sorry to interrupt. Sorry to interrupt my learned friend. 20% grant in aid was already granted. They are seeking 100% now.
2016, that is different one. That is not the subject matter here also. Subject matter is this one. 2011 GR was issued. Everything was done under that GR. They evaluated. I was passed in that GR also. They issued the letter saying that the grant in aid should be disbursed in my favor. In spite of that, they have not done anything. That's why in 2017, I filed the writ petition showing that I already completed everything. And in spite of that, they are not issuing the grant in aid in my favor.
So then eventually, when was it issued?
When was?
You are only asking implementation of 15/11/2011.
Yes, sir.
15/11/2011 GR.
Yes, sir.
As per which if you had claimed, and you are claiming only in 2017.
Yes, sir. 27.
6 years you filed the petition.
7
years.
In the meantime, 2014, they issued a letter. That letter is a part of my counter saying that you are already eligible for that. In spite of that, they have not issued. So we waited till 2017, saying that at least on that basis, some grant in aid should be disbursed in my favor. In spite of that, they have not done anything. So that's
at no point of time you were given grant in aid at all till the judgment of the court.
Yes, sir.
No, I'm sorry.
2016. 2016.
My learned friend may not be correct. 20% grant in aid is given.
When was it given?
2016.
2016.
To be very precise, as per GR dated 19/9/2016.
It was given 20.
Yes, 20%.
There is nothing very clear that you should be given 100%.
Not that. That disbursement of grant in aid should be the phase-wise manner, not in the 100%. Not in 100%. Phase-wise manner, state has to
Now, for the future you are getting regularly.
16, from 16, 20% I am getting.
but only 20% you are getting.
20%.
And the High Court judgment has been stayed or something?
Not stem proceedings, arising out of that was
Contempt proceeding. Even now you give only 20%.
there was a stay, so I believe
Not
that
stayed, not
authorities.
stayed.
I understand the contempt proceedings were stayed.
The future also you are not paying.
I'll take instructions on that.
What instructions?
Now that since 2001, but I am doing the same thing. I am running a school,
And more than anything,
that is a very small school.
more than anything, Mr. Sriram, what he's saying is that your education officer long back has actually passed an order saying the amount is not yet released, he should be released, they are eligible.
That's for
Specifically said
20%.
that.
Your Lordship, if your Lordship sees the Bombay High Court judgment, it clearly says that it is mandatory to follow the reservation policy.
Reservation line is not the issue before your Lordship.
All right, dismissed.
Grateful, Marat.
Item 21, I think there's a letter, Melos. I tried to mention it yesterday, Melos. Item 21.
What do you want?
No, this is a letter, Melos. We want to file additional document.
Huh? Okay, 22 billion. 23.
Your Lordships, in item 22, I am not opposing the letter, but could I request for a fixed date to be put in the matter?
How much time they have asked? What was the letter is for?
4 weeks.
4 weeks, Melos.
What for the letter?
But Mr. Tushar Mehta is leading.
23. Which year's matter is this? 23?
22, Your Lordship.
23. 1 minute, 22, 1 minute, 22. Sorry. Oh, that NCLT matter?
Yes.
Grateful, my lords.
What the- It's coming before us for the first time. What is good person. Not 23?
Please.
Yes.
But he next sitting and say that we have a meeting with your honor.
Yes, yes.
Please, lords. I am appealing for the petition.
I am appealing for the respondent.
They were
Second respondent.
3 partners, my lords.
Civil matter. Of a civil matter.
Sure.
Leave granted. Leave granted.
My lord, yes.
Sir, your lordships may kindly take it up any date time, even after vacation, my lord, some date.
Leave granted. You know what? We don't need to tell you.
This is as to Malat sir. I think a map would be a better help in this case.
What is this?
Because this is as to where is the placement, what is the size of the plot. That's our large defense as to quantification.
It's an award passed.
Yes. Well, both sides have gone on the field.
Both enhancing the compensation.
Only on point of deduction, my lords. It can be on next Tuesday, my lords. I am not feeling. Next Tuesday, I made a list of judgments also.
Because it will require
The deduction, how much deduction has to be
one of
done?
my contentions are
83% deduction is there.
it's a dry land.
You have also come in appeal.
Yes.
You have also come in appeal.
No. There is
But he'll file by us.
What more are you expecting?
the deduction on the point of deduction also, my lords. I have made a notes and all. It can be next Tuesday, my lords. I'm
Well, it's my
down with some.
contentions are that it's dry land. Well, it's on basically contents of land.
6 lakh.
There's no development around.
36,000 per acre to 6
Yes,
lakhs 36,000.
yes.
They have not come in appeal.
No, but my lords, on the point of deduction, my lords, I will make out notes. I will make it.
And how much is your tax?
83% deduction I have done, my lord.
Claimed only 10 lakhs. You got almost
My lord,
6.5 lakhs.
No, my lords. I am not that on point, my lords. I am only on the point of deduction. Next Tuesday, keep it, my lords. I will make it. Next Tuesday.
Be ready.
Only on the point of deduction, my lords. 83 deduction. I have some judgments of my lords in which lands how deduction has been. 4 judgments I am relying on.
God, doesn't matter.
No, I will.
Law here.
I am only referring your my lord. Next Tuesday I will make it.
If I do not matter, I just will accommodate.
Yep, I am highly appreciated.
No issue. Election. Alleged contempt. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22. 22 challenge the main order instead of pursuing contempt.
My lords, I filed the IA. My lords had directed me to file an IA challenging the August order.
Said it here, but
That may not have come on record. I filed an IA, my lords.
you make it clear that you will be entitled to challenge the order. Right? Yeah.
My lords, the only difficulty.
My lords, I appear for the respondent in this. My lords, largely it has been complied. My submissions are
No contempt.
My lords, if I may. Just one thing, my lords. My lords, the sole reason why they disentitled me was that I am married. That observation had been set aside by the High Court. They again passed an order saying, because you are married, therefore you are ineligible. So the entire reason why this went to the High Court in the first place.
The problem was you make your wrong choices. The moment they rejected your case, you should have challenged that 1st August 2019 order straight away. You would have got your relief. You are proceeding on contempt, and eventually the court said that there is no deliberate disobedience. Court said they considered in past orders.
My lords,
How can it be? You know the limits of considering what how a act should be contemptuous.
I understand what's falling from my lords. My lords, the direction from the High Court in the earlier round.
Permit you.
My lords, if I may, just for a second, my lords.
You know, we are not taking away your right.
My
We are saying that instead of contempt, you should challenge this order, and we will say that it will not be dismissed on the ground of delay.
My lords, just one submission, my lords. If my lords would have the order passed by the division bench in the earlier round, the direction was to conduct an inquiry, to consider my case, the hordes, the earlier, my lords of the High Court, my lords. The order which I was alleging as contempt. The direction was to consider my case, the hordes that legal position, and to also conduct an inquiry. My lords, this is my lords an appointment to. Yes, my lords.
But it is not deliberate disobedience. That is how I have perceived. What relief can we give? You can only say that contempt.
If my lords would just.
How will you get a relief?
My lords may just have
This order of 1/8/2019 continues to remain. Unless you challenge it, you can't.
My lords had earlier.
We understand you get stuck because your client's filing SLC. It's against a contempt order.
My lords, I filed the IA which my lords had directed me to. That may not have come on record. My lords may just.
No difference.
My lords may consider taking the.
We'll send you to the High Court. We'll protect you. Wait. Especially petition is against the order passed by the High Court on 23/12/2021, holding that there is no deliberate disobedience of the order passed by the High Court on 21/5/2019. Having considered the matter, we are of opinion. We are not saying that they are not deliberate. We are saying, having considered the matter in detail, we are of the opinion that the petitioner, we are of the opinion that this court will not be able to grant any substantive relief to the petitioner in the contempt proceedings. It is necessary for the petitioner to in fact challenge the order dated 1/8/2019 before the High Court, as by the said order, request for appointment of the petitioner was rejected. It is a case of the petitioner that the grounds of rejection are unsustainable for many reasons. This submission should, however, be made before the High Court and in proceedings under Article 226, challenging the order dated 1/8. Paragraph in view of the above, while not entertaining the contempt petition, we permit the petitioner to file a writ petition to approach the High Court by filing a writ petition under 226. The facts and circumstances of the case, the petitioner's may be considered on merits. On merits.
My lords may consider seeing one thing, my lord, subject to my lord's consideration, that my claim would not be set aside on the sole ground that I'm married, my lords.
My lords, that would be
That's
finding.
the core of the contention, my lords. That the marital status would not in any way affect the consideration of my claim.
My lords, my lords, if I may request, if my lords may,
Yes.
if my lords may consider saying that my lords may have not expressed any opinion on merits of the case.
You have not expressed any opinion on the merits of the
Deeply grateful, my lords, deeply grateful.
Thank you.
Lord's item 26, I am praying 3 weeks time to file my affidavit, my lord. Actually, there is a change of council. State council has been changed, my lord. We have to file that affidavit of the forest, state forest officer. Amounts has been already paid, but there is a difference in between. I love this.
These scales. They band. What's to be done at 27? Tuesday. The third. 28. Good feeders.
Please, your lordship.
Tuesday. Then 29.
29. I'm 28. I'm for the respondent.
28. Nobody has come. So put it on. You are here.
Yes, yes.
What is to be done in
Well, it's pursuant to Lordship's order dated, well, it's 5th of March. Plus, we have filed an affidavit. Lordship may kindly have a glance on it.
Kindly?
Well, Lordship may have a glance on it.
What does it say?
Yes, Mills. I will read. These are 4 paragraphs. I will.
What does it say, Kausar?
Yes, Mills. There are 2 Mills that it's respectfully submitted that the posts of inker feeder were incorporated in the recruitment rules of 1980 when there was manual process of inking in the printing press and the services of the inker feeders required. The post of inker feeder was part of section.
You come on third. We have a committee meeting. We have raising.
Yes.
We have to raise a little early. You come on third. You're not it. We'll just have a look at it.
Lordship may have it.
Third.
Third. Very well.
Not third.
On third.
Third.
Very well.
Just call if there are any.
Yes.
Just call the fresh matters.
29 years.
Just call the fresh matters.
Very well.
Mr. Ramchandran, no matter all these matters, after notice matters will come on third. None of them will be.
All matters
third
are 29.
Because next week, Monday is a holiday, so Tuesday will be miscellaneous.
So in sequence, Lord, all matters.
All these matters.
Very good.
We have not taken and passed over also. What happened to you? You were not well. Third.
Well, can I? Lords, can I?
Fresh matter.
Well, just for item 30, can I make a small request? We are writ petitioners all over 70 years of age. We waited almost 20 years for an implementation of your Lordship's judgment. Could it be a little higher up my matter, item 30? Because they're all 70 plus. I know that there is recent SOP saying. No, not me. The clients are.
All matters. Please don't mention. Any fresh matter is to be taken up?
Your Lordship?
50 only? Okay.
Lordship, can I mention item 43 after notice? There's an urgency challenging an insolvency proceeding and the resolution plans are invited on 31st.
Just in 2 weeks' time, don't make an issue out of them. Mr. Ramchandran, your matter.
Yes, Lord.
What do we do? Want it virtually become infractious, Mr. Ramchandran. That question of law We were only taking it up for the question of law, but otherwise the arbitration is gone on. So, proceeded further. We are not going to.
Your Lordship, may I please make
The implication brought there are number of cases, the issues are coming at
examine it.
And there is one.
We'll give it on a 2 o'clock matter. We'll put it on give a date for it.
2 o'clock, not I can.
Some date for 2.
My lords, item number 33, my lord. First matter. My lords, may it be high on the board on next week.
Review matters.
I must clarify there was some technical error with the e-filing portal. In some documents, therefore, that was request for me. That was the only thing. There was nothing other than that. I must clarify the impression. Not you are aware how things work. One message is e-filing.
That's why we wanted to see it.
Only adjournment.
You have done, we understand.
My lords, made item number 33, my lords. May it be high on the board, my lords, next.
We agree. All matters are coming on third. We will take it up.
March 50, your lordship. Item 50, fresh matter, your lordship. Your lordship, kindly come to page number 11, your lordship. So, I'm tenant, your lordship. I don't have any objection for vacation. Your lordship, page number 11, the Honorable High Court directed me to vacate. I don't have any objection. However, my security deposits to be recovered in separate proceeding, your lordship. Kindly come to page number 11, your lordship. It's an admitted fact by the PW1. She admitted that at the time of lease agreement, page number 11 of impugned order, your lordship. I don't have an objection for vacating that premises. My security deposit, your lordship, the Honorable High Court directed me to institute separate suit, your lordship, because the entire lease agreement arising out of my deposit.
What's the urgency?
Your lordship, 31st, there is a directions to vacate, your lordship, in the
31st.
31st January, in the fourth one paragraph.
It's on Friday. On Friday.
In the your lordship.
Just check and let you know. Okay. Yeah.